Welcome to A Way Forward, the right to recover.
Welcome to A Way Forward, the right to recover with attorney Richard Casey III, partner at Robinson and Casey, PLLC. Richard focuses on helping families navigate legal options when addiction or serious mental illness creates an urgent safety concern. His work includes Marchman Act cases, mental health guardianships, and advocacy around treatment access and oversight. I'm Lisa Mosbey, and today we're talking about what happens when a Marchman Act case does not move forward, including situations where a case may be denied or dismissed, and what families can expect next. Welcome back, Richard. Thank you for joining me.
Thank you, Lisa. I appreciate it being here.
Richard, families often assume that once a Marchman Act petition is filed, the court will approve it. Is it possible for a case to be denied or dismissed?
I really appreciate the question. Obviously, you're throwing the tough ones at me today. Um, there's always the possibility that court case can be denied or dismissed, and a family shouldn't be unaware of that potential risk. Um, I think that, there are no guarantees in life, and everybody's situation can be a little bit different. Um, Often that's not the case, but one of the biggest pieces of making sure that a case has the best chance of going forward is a good assessment. And so, one of the things that our team is very adapted to, and one of the biggest things that our team is very adept at, is identifying the best location for a patient to be assessed at. Each county may have its own procedures for what types of facilities can do assessments, and some counties authorize the courts to grant the assessment or order the assessment at private treatment facilities, whether they take insurance or whether they're private pay. Other counties will only allow certain named facilities, hospitals, or certain types of um, county-run programs to do those assessments. And, you know, each of those decisions has its pros and its cons. And each county, into the decision to move forward with a case in each county, has its pros and its cons. So while a case can be dismissed or denied, the chances of that usually are greater when the assessment results don't align with the requirements of the law. And so that has a lot less to do with the way that the case is prosecuted by the attorneys or the family as witnesses. If the facts exist and the patient does in fact suffer from a substance use disorder, it really is about getting a good assessment. And we have to make sure that we get the best outcome of an assessment by selecting where that assessment gets done.
Can you dive into that just a little bit more? What are some of the common reasons a Marchman Act case may not move forward through this assessment process? What are the things that stand out that cause it to be denied or dismissed?
Certainly, I think that in certain counties, assessing at a designated like hospital facility, that assessment facility may really just be overrun and busy, right? Like imagine that they are a hospital and patients are coming in with all types of conditions, and then also a patient comes in with a substance use disorder and needs to be assessed. Well, that hospital may not want to dedicate a lot of resources and time of their staff to doing as long of or is in depth of an assessment for a patient that a private provider would. And so when they're meeting with them, they might drug test them in that moment, ask them a few personal questions, take their word for it, and move on. And that cannot always be one of the better ways to get an actual assessment. And so the results of that assessment might say patient denies all substance use, tests positive for alcohol and marijuana, however, indicates that has prescription, right? Now, that other thing might be that if you were at a private treatment provider in a county that allowed it a private treatment provider, they might be able to take into account collateral information and other pre-existing medical records that indicate that he has a co-occurring mental health disorder such as schizophrenia, and he's abusing the marijuana, and the levels of the test come back from the lab as being extremely elevated, and so you can go into court and have that extrapolated set of evidence. Regardless of which case situation there is, our team is going to best push forward. But I will say that it depends on what the person who did the assessment comes in and testifies to, right? They have to then say on the stand, I did this assessment and this is my recommendation. And so we would work with the family to say and encourage you to relocate your loved one to a county that has a better chance or better outcome, right? We bring families from all over the world. We've got clients from Europe. We've had clients from Latin America. We've had clients from other states in the US, right? So, you know, there's zero, you know, reason that we shouldn't be able to explore, can we come out of the county that you're in Florida and relocate to a different county? And sometimes the answer is that's not going to work for me. I still need to move forward in my current county. And I'd say, that's great. We will support you. We will certainly continue to work with you. Here are the risks, right? The assessment may not be right as aligned because this county, right? You could have a great assessment in one case and not a great assessment in the next case, depending upon how busy that particular hospital system is, if they're the only county program. And so I'm not going to not advocate for your family on that potential. So it's not the only reason that a case could be dismissed or denied. Obviously, the way it's dismissed or denied is the facts do not meet the law, right? And the easiest way for that to be said so is if the assessor comes in and says, I do not recommend treatment, or even though I recommend treatment, I do not believe that this patient meets this criteria. I think it's important, though, to also indicate that that's not a high probability of cases. That is not a high percentage of cases. Often, we're not taking cases that are going to have a low chance of success, even in these remote counties. We practice any county in the state of Florida. And we've really seen that when even a case comes back with an assessment that indicates some type of, I would say, like less than desirable recommendation or less than desirable connection, there are ways to navigate that assessor to a different conclusion. And we will do our best to really put evidence in and walk that clinician through the thinking pattern of how does this person actually meet the criteria of the law and get us the best possible outcome for that family.
I think I need to go back a little bit and define what the difference is between a case being dismissed versus denied.
Sure, I think that a case could be dismissed. Let's say our client chooses to give up on the case, right? And they tell us they don't want to go forward anymore. And we can, right, advocate for them. We could advise them. We could counsel them. We could advocate for them to proceed on this case, even though it's a very good case. But if we are instructed by our client not to proceed, we might tell the court that we're no longer going to proceed, and then that case becomes dismissed. It is a process of essentially saying that the case is no longer proceeding, and that can be done voluntarily by our clients. It can be done involuntarily with or without prejudice if, for instance, we failed to even state a case, right? If there was zero facts, even in the allegations that even looked as though they could meet the requirements of the law, or if it was some other type of legal failure, right? Legal reason that there needed to be a correction, if you will, right? And most of those things are correctable. It's dismissed so that you can refile it and correct whatever that thing may be. Or it's voluntarily dismissed and you could refile it again down the road in the future. They're not finally determinative in most every situation. Something that's denied is actually when you've filed and gone the distance, if you will. Um, and and I don't want to get it overly confused, but there are different phases in the Marchman Act, right? And we might ask for something to be done as an emergency, but we are still wanting to do that thing in full. And the court might say, I deny it as it relates to it being an emergency, but I haven't denied the petition. It's just not an emergency in their eyes, and they're going to schedule it for next week instead. And so they don't get it heard right away. So a denial is just in the request, the court rules against you. And so ultimately the request could be as simple as, I think this is an emergency. It's denied as an emergency, but I'll hear your case next week, right? And then you still come and you have a full case. And then a full denial of a case would be as if in proving the case, in the process of proving the case, right, the facts don't meet the burden of the law. And again, that mostly happens as it relates to what the outcome of the assessment might be. But it's a lower probability that a case that gets that distance comes back with an unfavorable assessment.
And then, Richard, if a petition is not approved, what other options might families consider at that point?
Well, I think that the Marchman Act is never an isolated tool, right? So the Marchman Act is one
Okay.
tool to get a patient into treatment and to help keep guardrails to put pressure to keep them on treatment. One of the things that families have to recognize is that like there is not a one and done shot at this. So it depends on why the case was denied in that process, right? In that assessment process. Maybe the case was denied because the patient had never been to treatment before, ever, and the assessor was unable to say, right, that a patient was ever had a history of lacking compliance with treatment for substance abuse. That is actually one of the requirements. And so imagine the case is denied because you're unable to prove that a patient has a history of lacking compliance with treatment for substance abuse. And so they were assessed, they're in a treatment program, they're recommended to be in treatment, but the assessor is unable to tether together the facts and actually actually testify that they believe that they have this history of lack of compliance. And then the case is denied. Okay, if the patient stays in treatment, the family's outcome is generally gained, right? Their outcome goal is that they stay in
Yeah.
treatment. If the patient leaves treatment, then all of a sudden, interesting fact pattern change. The patient seems to have lacked compliance with treatment for substance abuse, and they can refile the case based upon the patient's leaving treatment because the
Right.
fact is now present, right? So it's hard to say in the abstract exactly how everything could play out. But again, there's always having a therapist. There's always working with a case manager. There's always having a family systems, right? Like case management firm, a consultant working with you. There's the therapy programming for families in the treatment environment that likely connected you. There's Al-Anon services. The family needs to have this team of people supporting them. And even if it's something that, money is an object, Al-Anon is a free service, right? And if you have insurance that can send your loved one to treatment, you probably have insurance that means you can go to outpatient therapy with a therapist who specializes in substance abuse with families. And there's a lot of anxiety and depression that comes from working and having a family member who's going through addiction. So you should be able to hopefully access therapy for yourself as a family member. But I also point out that the case is not one and done. Even when a case might be denied, it doesn't mean you give up the fight. And I don't want to have to file these more than once. I do not want to have you come back. I want your patient and your loved one, right, the respondent, to get treatment and be sober. I think that he deserves or she deserves an amazing life. One that I myself have, because I'm in recovery and I know a lot of people in recovery, right? Our goal is to help people get that outcome, but that doesn't mean that if it doesn't work the first time, I throw my hands up and walk away. We have to look at what's going on. And sometimes that is, you know, doing another intervention, or right, like having a case manager work with the family system, or monitoring if they leave treatment, and then, you know, putting the pressure back on them. Sometimes it's the subtle reminder to the patient, hey, if you leave now that it's denied, I can refile this. And you only won because you hadn't been to treatment before. Leave again, and we'll be back. And then you don't even need to file it. Sometimes it's the enough has gone through that he feels like, or she feels like, she was successful in the case. And I have a great example in my mind. I'm thinking of a family where ultimately there hadn't been a proof of that fact. And we just kind of said I just kind of claimed to that family, let her know, but if she leaves again, we will refile. And the court did us a favor, even though they denied it, said, and if she leaves again, you should come back. Right. And so it was clear to the patient, and it was clear to the family that this is exactly the scenario. We're going to give her a chance to do it voluntarily in this moment, but ultimately over the long haul, she'd better stay in treatment, or, you know, the things she thinks she avoided today will be exactly what happens anyways. Right. And to me, that's what you're looking for. You're looking for treatment. You're not looking for a piece of paper with the judge's signature. You're looking for a patient who's in treatment.
That's a lot of details to unpack for me, but sitting on this side, what is I'm so aware of is that the assessment, if it doesn't go well in one county, we have other options because you can move counties. A denial or a dismissal is not the end all be all, that you can refile, that you can go away, you know, come up with a new plan, a new strategy, and come back and file again. The main goal is to create that pressure for the patient so that they get help. It's not about getting them to go to jail. It's not about, you know, consequences of any other nature than to get them back into a position where they can start to heal and be well again. Did I sum it up right? Did I miss anything there?
In a lot of ways, yeah. I think the one thing I would say is that we want to do all of that strategy before the case ever begins, right? We have these opportunities to know where we're going to have the strongest chances of success. And a lot of families come in with this preconceived notion of what's possible or not possible. And when they're talking to us, we're advising them of, listen, it would be better if we did Y. And I would just encourage that families listen to that legal counsel, because there are reasons that we know how high and low the risk profile of particular decisions could be. And what we're trying to do is give you the best possible chances of success. There is no guarantees, and we know that the chances are relatively high when you come through our doors, but that doesn't mean that we don't want to help you navigate to reduce those risks before we have to start. And if those risks arrive, that doesn't mean that we don't have solutions or processes or steps that we could deploy to help get that loved one back into treatment. To me, leverage saves lives. And so the more pressure or leverage you can use to get that patient into treatment is the easier you can get those guardrails up, those bumpers on the bowling alley, if you will, and you ultimately can keep them in the path of recovery. You've got to have that pressure. You've got to put those boundaries in place, and you have to know that leverage saves lives.
That's where we'll leave it today. Thank you so much for your guidance on this. Leverage saves lives. If you need to find some leverage, you know the right place to go, folks. That's it for today's episode of A Way Forward, The Right to Recover. If you'd like to learn more about Richard Casey and the work of Robinson Casey PLLC, including resources related to the Marchman Act in Florida, visit robinsoncasey.com. Thank you so much for listening. Don't forget to subscribe, leave a review, and please share this episode with someone who may be trying to help a loved one through a difficult situation. And we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.